Okay, perfect. All right, so tonight we're going to just go ahead and get started. So I'm Stephanie Black, co-founder of Credit Butterfly. And today we're going to talk about the truth about bankruptcy removal and why it can destroy your client's credit. So this is like, I don't know how to say it. This is very near to my heart. So there's a lot of misconceptions out there in the credit repair space on what is good for credit, what is bad. There's a lot of these little fads that go around. They teach you how to do things, but it's not always good advice. And so this is a good exercise for us. We're going to hear from an attorney today. And can I just make sure everybody's muted? Um, so again, you guys all know me. We have Credit Butterfly, and at the end, we'll talk a little bit more about that. You guys can get a demo. You guys can get a free trial for Credit Butterfly. But I want to get moving pretty fast tonight and just introduce Haseeb because he has a lot of information to share with us. And so I'm not going to do too much talking on my stuff tonight. I'm going to let him take the floor on most of it because I really want to get this information out. Haseeb has a consumer law firm in Chicago. So if any of you guys are going to be in Chicago, or if you guys are in Chicago, or if you're around Chicago and it's a quick drive, or you would just want to go, Smart Credit is hosting a 2-day event on the 25th and 26th. I did post it in the Credit Action Plan group. It's a 2-day event. One will be just, I believe, like a mixer, where you can, talk to people and network that the Smart Credit is putting on. And then Saturday will be a full day master class with Rob, the credit guy. There'll be a funding. They're going to talk about funding. We'll be there. Credit Butterfly will be there talking about FCRA violations and teaching on that. It's a great opportunity to network, meet fellow credit repair owners, and also Haseeb will also be there in Chicago as well at the Smart Credit event. You can also follow him on TikTok. He is a big TikTok star. He's the founding partner of Haseeb Legal. And he was the keynote speaker for the National Association of Consumer Advocates annual conference, navigating FCRA's evolving landscape in 2024. So I am going to just introduce him now and let him just tell you a little bit about himself just for a moment, like a minute or so, Haseeb, and then I'm just going to go over our agenda for today, and then I'll let you get into it.
Cool. Hey guys, can you hear me well?
Yep.
Okay, perfect.
Yeah.
Hi. So I'm Haseeb. I'm consumer attorney in Chicago. You may have seen me in random Facebook groups through also Credit Repair Cloud podcasts and maybe even TikTok. I talk about consumer rights, debt collector harassment, credit repair through lawsuits, through litigation, through FCRA cases. But I guess the biggest thing we're going to talk about today is a big part of my practice, which involves bankruptcies on credit reports. It's like my bread and butter. I file like 3 or 4 of these lawsuits every single day against all these credit bureaus. So, yeah, I'm excited to talk to you guys.
Great. Awesome. All right. So we're going to talk about what happens when you actually remove the bankruptcy today. So he's going to tell you why this really matters for your business, what it can do. Like, I think you're going to be shocked, honestly. If you haven't seen him talk before, if you haven't heard this, then I think you're going to be truly shocked with what you're about to hear today, because it is not what you get out there. Okay, from the experts that are teaching you how to do things. So uh, take notes. Okay, what does Jay Will always say? Note takers are money makers, right? So take those notes because you're going to want to remember this, and we will also have the replay up for you guys to have as well. So he's going to talk about what we call, understanding the bankruptcy myth, right? Because there is a myth out there. People think it's a good thing to remove their bankruptcy judgment. We're going to talk about strategies to get that 700 plus credit score right after a bankruptcy. It does not take much time. I'll talk about that piece after Haseeb is done. And then you're going to learn how to scale your business using these tactics, right? That he's going to teach you today, and ways to make more money, have another income stream. And just wait until he tells you. You don't even have to wait. It's not even like a regular FCRA violation where you have to wait. So this is the exciting part. So I'll let him tell you about that, because you guys can have, it's literally just money in your pocket. Your entire database is probably sitting there just loaded with cash for you, and you don't even know it. So we will go ahead and, oops, did I lose my? Okay, are we seeing shifting your mindset? Does everybody see that one? Shifting your mindset about bankruptcy?
Yes, we see it.
Yep, okay, perfect. All right, so we're going to show you today what CROs are mostly doing wrong when it comes to bankruptcy and removing bankruptcy from credit reports. And I'm just going to go ahead and let Haseeb take over here. The big bankruptcy myth. Can you remove my bankruptcy? How many clients call us every single day wanting to know this very question, right? That's always what they're asking. Hey, I have a bankruptcy on there. Can you take it off? Right? Why do they ask for that? You know, why are we removing them? Right? And what does the law actually say about that? So Haseeb, I'll let you just take it away from here.
Yeah, it's so funny. I guess it's like the biggest thing in credit repair. Everybody's so caught up in how do I get the bankruptcy off my credit report? I think that's the only way I'm gonna move on. It's the only way I'm gonna get credit again. And though it might be true that right when you file for bankruptcy, right when you get a discharge, it may take a little while to start getting credit approvals again. Like, and some credit cards are more favorable than others in approving you for credit after a bankruptcy discharge. But I don't know where the thought comes from, or where the theory comes from that having a bankruptcy public record removed from a credit report helps somebody. Now, I get credit reports every single day, and all of them either have bankruptcies on them or they don't. But the ones that have bankruptcies on them, I get them after a credit repair company sometimes has started disputing, and somehow through, I don't know what methods they do, sometimes bankruptcies do come off as a result of credit repair. But tell me if this makes sense. If a bankruptcy comes off a credit report, but there are still accounts reporting bankruptcy statuses on them, what difference does it make? A creditor will know that somebody filed for bankruptcy either way, whether it's on a credit report or not. So everybody just thinks that having a bankruptcy on a credit report affects their FICO score, but I've seen it go the other way. I've seen bankruptcy. So I've seen bankruptcies come off a credit report and then the other two continue to report them. So like, let's say Experian removed the bankruptcy for whatever reason through dispute techniques, or sometimes they just remove them. But I've seen the other two bureaus who have the bankruptcy on the report actually higher scores than the one on Experian. Let's talk about reasons for that. The biggest reason sometimes is actually the fact that these credit bureaus have methods to suppress balances on accounts that were supposed to have been included in bankruptcy. It's in a very big case back in 2007 called White versus Experian. It was a class action, and in that case, it was a California case. In that case, Experian and all the credit bureaus have agreed as part of a nationwide class action to implement bankruptcy scrub procedures, because a lot of people know about the FCRA in the realm of, hey, if we send disputes and we don't fix it, then we have a claim. But there's another aspect of that the FCRA requires, that credit bureaus are required to assure maximum possible accuracy through reasonable procedures. If they don't have reasonable procedures to assure that, they can be sued without even disputing it. And this is stuff, the focus on this is internal inconsistencies within the credit report. Stuff that the bureaus unilaterally should know without you even having to tell them. This is where the bankruptcy comes into play. When you remove a bankruptcy, the indicator that the credit bureaus get to suppress balances on the accounts that should have been done away with in bankruptcy gets ripped off. And now these balances start popping up that should have been included in bankruptcy and done away with. And now your credit score really goes down because accounts that were supposed to have been suppressed and zeroed out balances and updated with included in bankruptcy statuses are now reporting as several $1,000 charge-offs. That's a bigger problem than having a bankruptcy on a credit report reporting. So that's it doesn't happen all the time. Sometimes credit accounts stay the way they are even after a bankruptcy is removed off of a credit report. But the inconsistency in when you go apply for a credit, or when a consumer goes and applies for credit, of seeing a bunch of accounts reporting is included in bankruptcy but no bankruptcy in the public record, that inconsistency, I've seen people get denied credit on that basis before. It's just confusing. It makes no sense. The creditor will just assume, oh, they probably had a bankruptcy. Mortgage lender, they probably had a bankruptcy and they just got it removed somehow. They're going to know you filed it either way. And people think that the removal of the bankruptcy in the actual public record affects the actual score a lot, but that's not necessarily the case. It's not such a bad thing having a bankruptcy on the credit report. It's worse for you if you don't have it and you have balances popping back up, or you just have accounts reporting as if you're included in bankruptcy when there's no explanation for it in the public records. So these scrub procedures that the bureaus have implemented as of 2007, the way they work is they get notification of a discharge or a dismissal of your bankruptcy from LexisNexis or some other data vendors, but it's mostly LexisNexis. That's why you're always hearing of these credit repair methods of disputing it with LexisNexis or disputing it with the bankruptcy court, which I still am trying to wrap my head around because I don't quite understand that. It's not illegal for anybody for a bankruptcy to be reporting on somebody's credit report. I don't care what anybody tells me. If a consumer filed for bankruptcy, there is no legal basis for that not to appear on a credit report. So a lot of people tried to litigate this with my law firm and say, hey, like what can we do about this bankruptcy? I told them, like, if I go in front of a judge and say, hey, look, this bankruptcy is reporting on this credit report, it's inaccurate because the bankruptcy court doesn't report to the bureaus, the judge is going to laugh me out the courtroom because it makes no sense. Did he file for a bankruptcy or did he not? At that point, I have to tell the judge, yeah or no. And my answer is always going to be, yeah, it's just a bankruptcy that they filed, but they just want to get removed. It makes no legal sense. The FCRA doesn't protect against stuff that you want off the credit report. It protects you against things that should not be on your credit report, inaccuracies, things that you didn't file. And this is the same legal theory as the reasonable procedures theory under the FCRA, rather than the dispute theory, as accounts that are reporting in twos, like double account or two accounts reporting. We also make the argument that disputes aren't needed for those types of cases either, because, like the FCRA provides for, they need to assure maximum possible accuracy through reasonable procedures. This is a theory of liability that we sue credit bureaus under the Fair Credit Reporting Act when there are bankruptcies on the credit report, accounts that should have been done away with in bankruptcy, zero out balances, anything reporting other than and included in bankruptcy status. If that's not happening on every single account on people's credit report, that's an FCRA violation. And we sue for that. We file these lawsuits pretty much every day of the week against three credit bureaus. So just get that out of your head, that a bankruptcy on a credit report it's the first thing that needs to be removed. That's not the case. Also, I guess we can maybe even get to this a little bit later, but it makes our job harder as an attorney when we get sent these files and bankruptcies are removed from credit reports and there's still balances reporting. Now, when you try to dispute those balances and you already got the bankruptcy removed, Well, what's your basis of getting those balances off? Are you gonna say, well, those are included in bankruptcy, they need to come off? Well, you also said that the bankruptcy wasn't yours, so which is it? So there's a lot of inconsistencies within the credit repair space that can be cleaned up, but it starts with recognizing that bankruptcies on credit reports are necessary. Let the time come and go. That'll come off the report in due time. Focus on the accounts.
Yeah, that's such good advice. And that's how we've always trained here too. In the credit action plan, we've always trained you go after the accounts. You don't go after the bankruptcies. It's just completely unnecessary because you can get a 700 credit score within 6 to 8 months, typically after a bankruptcy is discharged, just by doing proper rebuilding. So let's just talk about what should credit report owners be disputing on the credit report if they dispute anything. Like it you can dispute or you don't have to dispute. That's the one really beautiful thing about your law firm is that you don't even really require the disputes. But if we are going to dispute it, what would we really be disputing? What is a real violation? Let's talk a little bit about that. What is a real violation and uh what is not an actual violation? Because a lot of people think that just a wrong date here or there is like an actionable violation. It's just really not. You can't prove damages a lot of times on stuff like that. So talk a little bit about that because I think that's where a lot of people get so confused because they're not sure because there is just so much misinformation out there all over the internet now about this. So just maybe clear some of that up.
Yeah, and I love that you pointed out damages because even though something might be off on your credit report, is it material to you getting credit? Is a creditor going to deny you on that basis? That's what should always be going in through like credit repair's head before they want to send it to an attorney, or what goes through my head. Um, think about it this way: is like is an account date of an account being open 15 days late versus being open on the first of the month, is that going to are you going to get denied credit on that basis? Yeah, technically it may be inaccurate. Dispute it, get it fixed. It should get fixed, but is that going to be the reason why you get denied credit? Probably not. What's going to be the reason why you get denied credit? Well, in these bankruptcy cases, I'll tell you what is material to that. What's material to you getting credit, or it can affect your rate when you do apply for a credit card. Balances that are on a pre-petition bankruptcy account, an account that was included in bankruptcy. Let's say you file for bankruptcy, you get a discharge, an account still reporting a $6,000 charge off. Inaccurate. That's number one. Number two, let's say an account was open after the Chapter 7 petition date. Well, how is that possible? How can an account be open after the bankruptcy, but then reporting as included in bankruptcy? If the trade line is reporting included in bankruptcy for all accounts opened after the bankruptcy, inaccurate. I mean, it's just not possible. And a bankruptcy status on a trade line in that case would be derogatory. So it would just get stuck in that status. Let's say you've been making payments on that account month after month, and they're all on time. Inaccurate. You're not getting credit for it. You're not getting positive credit for it. So you would have gotten credit for it if they had not put that indicator on the report. That's something else that you can dispute. Another thing is like if a bankruptcy is dismissed, bankruptcy has been dismissed for a year or two, but Experian, Equifax, TransUnion have kept this account as included in bankruptcy and kept it in this status. After the bankruptcy was dismissed, all those accounts that were in the bankruptcy at one point should revert back to normal reporting. They should just revert back to payments being made, business as usual, out of the bankruptcy status. The fact that they're kept in that status keeps you from building your credit back up. Also, damages. So damages can come in the form of positive credit history that hasn't been applied to your account, but it could also be in the form of balances that they're saying that you owed, but you actually didn't because it was discharged. There are a number of other bankruptcy related inaccuracies that are that actually. I think somebody's got it on
Darius, can
mute.
you mute yourself? Thanks. Go ahead.
Oh, I got muted too. I just unmuted. Okay. So yeah, with regard to the bankruptcies, another type of an inaccuracy are like, let's say something was taken out of the bankruptcy, like a reaffirmation. What that means is you made a side agreement with one of the creditors of, hey, we won't discharge in the bankruptcy this account. I will be making payments on this, and this won't be included in the bankruptcy. Sometimes credit bureaus will suppress that or make that account look like as if it was included in bankruptcy, but the docket clearly shows that it wasn't. At that point, I would dispute it to let the credit bureau know this account wasn't included in my bankruptcy. All the payments that I made on this account should be positively reporting, and I should get the positive credit for it. If they don't fix it, you have another case. And there's several of these. Sometimes it's like a charge off, just an indicator of a charge off after a bankruptcy filing date. That shouldn't be happening. Lates after a bankruptcy filing date also shouldn't be happening. And these are all things that a creditor is going to judge you for. A creditor will hold this against you when you apply for credit. So these things, if they affect your ability to get credit in any way, we got damages. And these are things I'm going to want to bring a lawsuit for. But like I said, if you want to dispute it in these cases, great, go ahead. Sorry, yeah. If you want to dispute it in these cases, great, go ahead. It will make the case a bigger value case, but not necessarily. It doesn't necessarily have to be disputed because we bring this under another section of the FCRA, 1681 EB, as opposed to what everybody knows is 1681I, the failure to reinvestigate. This isn't about reinvestigation. The Bureau should have got it right from the get-go. They should have never made this mistake to begin with, because they should have had procedures in place to make sure of it. So disputes not needed. We bring these every day of the week without it, and it just becomes a case as soon as we see it.
Yeah, that's awesome. And just so you know, for all of our Credit Butterfly users that are on the call right now, the exciting news is that we're actually adding Haseeb's legal team or into Credit Butterfly. So by next week, you'll actually have access to be able to send your cases to him right through Credit Butterfly when they're ready to go. And like he said, you don't even have to wait. If you have a bankruptcy, even if you have just somebody with a bankruptcy on there, even if it's not popping a violation up in the system, we have, just so you know, there's some new logic in the system, so it does recognize the bankruptcy issues, and we're working with Haseeb for it to recognize even more bankruptcy issues so that you can flag those right away. But you'll be able to send those to him immediately. You just send him the credit report and he'll look it over for you, right? They don't even need to send the dispute. You can just go ahead and send the credit report to him. So anybody that's in there, like, you can do it. And even if you don't have Credit Butterfly, if you're on this call today, the cool thing is he's going to give you the information. You can send your credit reports to him with anybody that has a bankruptcy on there, whether you use Credit Butterfly or not. You can go ahead and send it over to his office, and he will look at that, let you know if you have any violations, and go ahead and take care of that for you. And you do, of course, get compensation for that.
Exactly.
Yep. So, all right. So is there anything else we need to know? Because we're running short. It's like 4:30 already. I'm going to talk a little bit about the rebuilding piece to get the clients back up once they have discharged their bankruptcy. But is there anything else here that you really feel we need to know more about just the bankruptcy in general that
So
could benefit the credit repair companies?
this is Kimberly. I wanted to know what the legal exposure for CROs is that when they remove a bankruptcy.
So when they remove a bankruptcy after a credit repair organization disputes it, or just unilaterally.
So that so when CROs just, market that they can remove bankruptcies and just
Like
do
it's not mine, saying it's not
Yeah.
there or something like that.
Yeah. So actually, I haven't tested this yet, but I thought about it, and because I get a lot of these where I lose cases because CROs disputed the bankruptcy off. Like my goal is to get balances off, and then I can't come around and say these balances should come off because they're included in bankruptcy when from the looks of it, it looks like the consumer said that the bankruptcy wasn't theirs. I don't want to put these consumers in any perjury situation or any federal filing have anybody accuse them of perjury. But if in the case that if they remove it, technically removing it is an FCRA violation because they should have reinvestigated it, looked up the public records, and kept it on there. So technically, it's a technical violation, but I wouldn't bring it because I don't want inconsistency to arise in these cases when and trying to get the bankruptcy back on the report, because that would be the result of it. That's why I stick to what these cases, the ones that I file, because the result of it usually is they will delete the account completely. Two of the bureaus would delete the account completely as a result, instead of even updating it to reflect included in bankruptcy status and $0 balances. I'd rather have the account off the report because it makes it look like I never opened it in the first place. Way better for my score than either a bankruptcy indicator or a balance. So, but I wouldn't fight to get a bankruptcy back on a report after a CRO tried to dispute it off.
All right. And so, but really what we just need to understand about this is that you ruin your own case. Okay, so if you have a bankruptcy case, you have a bunch of balances that were sitting there that weren't updated and included in the bankruptcy, or some other issues that are arising on the credit report in general, then you go in and the first thing you do is go remove a bankruptcy. Now you don't have any actionable case, right? It's going to get thrown out because now you can no longer bring litigation or do anything about the inconsistencies of the bankruptcy, because you already said that bankruptcy didn't belong to you or shouldn't be on that credit report, and now it's off. So therein lies the issue.
Exactly. And I have a few hundred credit repair organizations that I work with that send me these types of cases all day long, like with these bankruptcy credit reports. And I tell them, hey, I want a fresh report where you never disputed anything, because I know what CROs do is the first thing they target is a bankruptcy, and they say it's not mine, it needs to come off. Once that happens, it makes our cases harder because we're fighting accounts. We're getting account balances removed that should have been removed to begin with. And once letters are sent on behalf of a consumer, the credit bureaus come back and say, well, which is it? Do they want the bankruptcy off or do they want the balance off? Because you can't have your cake and eat it too. You're wanting it both ways. So think about what actually is better for your consumer. It's the balance is coming off the report. Debt to income ratio.
Yeah, because
Hey, Stephanie.
Yeah. Mm-hmm.
Neil Yagley here. How are you?
Hi, good. How are you doing, Neil?
Good. I just want to reiterate that the gentleman said, and we have a deletion rate of 75% of bankruptcies within 6 months or less. I'm not going to get into that because that's for another time. But the one thing he's exactly 100% correct on. We never, in all the bankruptcies we deleted, never ever dispute, never mentioning that this is not your bankruptcy. It's based on really getting violations based on inconsistencies, discrepancies, reportability, and things like that. I just want to make a comment, but he's absolutely 100%, because if one of my team members does that, I find out he's terminated, he or she. But anyhow, I just wanted to make and emphasize that he's 100% accurate by saying never ever regarding how new, what type, or anything like that. Never disputed. It's not yours.
Yeah, exactly. I mean, and we should be doing factual disputes, right? Thanks, Neil. We should be doing factual disputes. We should not be making things up to get things off. And it's not
Correct.
to say back in the day we didn't all do that, because you know what? Frankly, we probably all did. And it doesn't not work anymore. It's just not the way to do things. And so we're trying to teach the right ways to dispute, the right ways and better ways now to use consumer law to get better results for your clients without having to worry about getting everything deleted. So like I'm going to go through this part really fast because I'm sure there's questions out there, and I really want to leave some, at least 20 minutes for questions today for Haseeb. So one thing, like we all know, you do not have to remove that bankruptcy to get to a 700 score. This is what I think most people just don't understand. All you have to do is rebuild immediately. Okay, immediately rebuild. What we do, and we have always done, I've been in the loan space for 25 years. We want to make sure they have at least 3 open accounts after that bankruptcy. They start using them responsibly. They're keeping the utilization low. We want to see at least 2 revolving credit cards. There's secured cards, no problem. That will take them, it's not even hard to do. It's so easy. 1 installment loan, get them the right mix, keep that utilization well under 30%, make your on-time payments. And I promise you, in 6 to 12 months, they're back at a 700, as long as they don't get new derogatory information reporting on that credit report. Now, if they do have recent new derogatory information on the credit report, and you got to look at those dates, you guys, you got to look and see. Look at when the discharge date is on that bankruptcy, and then look at the date that the account was open, and you're going to know whether or not that should have been included in the bankruptcy. Now, if it's something that was not included in the bankruptcy and came on after the bankruptcy discharge, then you need to do something about those items immediately. Okay, there are fixes for all of these. Like, you immediately need to handle that account. A lot of times it's little collections that will do a pay for delete. Just get it off of there. The score will shoot right up. Okay, it's just not that difficult, but you do need to explain to your clients when you're talking with them about rebuilding after bankruptcy. Let them know what happens when you actually get something new derogatory on the account after. I'll tell you what happens. It's like a 150-point hit for one tiny collection. Okay, I've seen it. Happens. You get the collection off and boom, it just goes right back up. I had a client that actually happened to 150 points, one tiny little medical collection. So it is a huge hit. It hits you harder in the scoring range after you've had a bankruptcy if you get a new collection. So like now, somebody that doesn't have a bankruptcy, say you get a collection, it's like maybe 60 points. But if you have had a bankruptcy, it's a much harder hit. Okay, in my experience. For secured cards and loans, you guys, I use Credit Card Broker. Everybody should be using Credit Card Broker. If you don't have access to secured cards or credit builders, you guys definitely should. I use different ones, but everybody should be signed up and monetizing these types of things. This is just another income stream for your business. Secured credit cards. I mean, they pay like $30 a pop for most of them. So it's a good income stream, especially if you target like bankruptcy attorneys and you get their people that are coming out of bankruptcy. It's a great way to make additional income. So again, Credit Card Broker, you want to know about Credit Card Broker. I mention this on the call usually all the time. So most of you guys have this information. If you don't, hit me up. I'll give it to you. So that you can have access to these types of credit builder cards and secured credit cards as well and get paid for them. I'm going to open it up to questions. We're on perfect timing right now. We have about 20 minutes, so I'm sure there's plenty of questions for Haseeb. He is a big TikTok, like viral TikTok star, you guys. Don't you have some like viral videos out there?
When I first started talking about like how to sue a debt collector, when TikTok first started, that stuff went crazy. So it was kind of like a snowball effect from there. I've transitioned to talking about just a bunch of random stuff now, but yeah, initially it was a lot.
Yeah, Haseeb knows his stuff. He does these all day long, especially these bankruptcy cases. He does everything, by the way, not just bankruptcy cases. He does all of the different FCRA violations. So if you guys have questions, you guys can either put them in the chat. I'm going to go check the chat right now, or just unmute yourself and go ahead and ask. Just raise your hand and we'll just go by line of hands would probably be the easiest if you have a question
I
for
have a
him right now.
question.
This is his email and this is his phone number. So everybody take a little snip of that, take a picture with your phone so that you have his information.
Yeah, and you could email me if you have credit reports that you want us to take a look at that have bankruptcies on them. You can email them to that email. 3 bureau reports, annual credit reports, PDFs, everything's fine. We have a team that just as I'm on this call right now, they're looking at credit reports. So we spot those bankruptcy violations. So those no questions asked. You can always send those over. Other than that, like through Credit Butterfly, if you have cases set up for us to take on, happy to do those too for you guys.
Okay, so Brandon has raised his hand. Go ahead and ask your question.
Hello, I have a question. Thanks so much for all the great information. It's awesome. Just want to give you guys some props for that. I have a question about, so when an account is charged off, where is the violations that you've seen in your experience?
If an account is charged off, where's the so when an account charged off, some stuff that I would see is if it's placed in collections for any reason, if the collections and the original creditor are reporting the same balance. It's okay if one of the accounts is reporting a $0 balance and then the other's reporting the complete balance. But when there's duplicative accounts, when a creditor and a charged off account is in collections, they're both reporting the balance. It makes it look like you owe it twice. That's the biggest thing I see with charge-offs. Another thing is like charge-offs reporting after a bankruptcy discharge shouldn't be happening. It should just get zeroed out, included in a bankruptcy status. But those are the biggest issues I see with charge-offs.
And balances, like if it's been paid off and they're still
Yeah.
reporting a balance.
Yeah.
So meaning like, so if ABC Bank, you charged off $5,000 and then ABC Collection Company bought it for pennies on the dollar, and then they're showing $5,000 as well. And
Yeah.
then but they already had sold it, so it should be off their books and wrote it off, ABC Bank, then that's when there's an issue right there.
Yeah, I mean, it makes it look like you owe $10,000 instead of the $5,000. So you could dispute that. If they don't fix it, we'll take that case. But like I said, 1681 EB procedures. I would argue that the bureaus might have had an obligation to detect when that happens to prevent it from happening. So I would bring those on both bases, but I know you guys dispute and then get results. But if you want to not wait that long and see if there's a case before then, and not risk losing the case if it does get fixed with the dispute, I would approach it via EB under a procedures claim.
Okay. Yeah, I was just curious about that. I mean, I don't do any disputing, so I more outsource that. So I'm not in that space. I always partner up with reputable credit repair companies, but I like to see the report first before they touch it, because if we can just send it over to you before it's even disputed, that way it could be already, you know.
So yeah, I think the best reports to send us are the ones with the bankruptcies on them because we can check without anything else with all the information provided to us within a credit report to know whether something is inaccurate or not. I don't need to ask the client, "Hey, is this inaccurate?" No, because I could see within the data. But everything else, like if it's like identity theft, your client might know better than I would whether something was on the report that shouldn't be because it's their report. I wouldn't know. So those types of reports, I think you guys can build out those cases through Credit Butterfly and then get to the point where you send it to us. But the bankruptcies on the credit report, those 3 bureau reports, send those to us because that has all the information I need to see whether something is a case or not. I don't have to ask any more questions.
Got it. So you prefer the bankruptcy cases over any other types of
It's
specific
not
cases?
it's not that I prefer it at all. It's that I those are the ones that you can send me without thinking. But the other types of cases, I actually prefer those. Those are bigger value cases, but those need to be built out for before they get to us. And that type of build out, I think you could do through Credit Butterfly, identity theft disputes and stuff, and then get it to the point where it can be sent to us. But the bankruptcy reports that can be sent without thinking, because if you see a bankruptcy on a credit report, send it over. There's a 15 to 20% chance that we'll see something that we can do something about.
Got it. And then the other question I had was with the I'm spacing here. The charge off accounts. So they're supposed to be reporting a zero when they do sell it, but then they sometimes don't report the zero, right? And then or they'll put charged off and then sold or something like that. Or is the wording important too? And then
It,
I forgot to ask you about the identity theft. So identity theft, if they remove the item, then you no longer have a case, right?
identity theft, if they remove it, it's likely that you might not, yeah, because if they reinvestigate it and the result of the reinvestigation is deletion, that you what are you going to sue the bureau for when they did their job?
Got it.
Yeah.
Yeah, I actually had an identity theft case this week for one of our users. I think he's on the call actually. And his client has an identity theft case. So we did the dispute and it had 3 items on the identity theft report. It was actual identity theft. And 2 of them got removed, but 1 didn't. And guess who? Guess who didn't remove it? Anybody guess? Make one guess on which bureau didn't
Equifax.
remove it.
Equifax.
No,
Experian.
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 Experian. It's
Usually
usually
everybody
Experian.
gets that because Experian just removes nothing. They'd rather just go ahead and settle cases. So now there's a case for Experian. It's just one. So there's an actual case, but we did the whole dispute. Everything's done. Now we have the whole thing packaged up. So.
Wow, that's crazy. Was the actual identity theft like did the person even have any clue like what it was like what credit cards and
Yeah,
they
just
were opened
bona
up?
fide. Yeah, I didn't. It all happened in the same time frame. It's just bona fide theft. Yeah.
Wow.
And there's a lot of that out there. I mean, I see a lot of real, true identity theft. So here's a question in the chat. It says, but if we are outside of the window and there are no open accounts tied to the BK, so I'm thinking if it's over 7 years and there's no, accounts tied to the BK and the client wants it removed, then can we remove them?
I mean,
Will it do
technically,
anything?
I don't think it'd have much of an impact. I think when you're that far out after a bankruptcy, it's like that's not affecting your credit as much as it was when it was fresh. So it's not, I don't think it'll help them too much, nor do I think there's a legal basis to get it removed. You have to wait the whole period. So yeah, I mean, if there's nothing, I don't like, if you guys want to do it by all means. If your client wants to say, if it's their, my biggest suggestions to CROs is put your client in any risk of perjury or any frivolous disputes, because it does when they get those types of disputes. I do think the credit bureaus treat that client differently in regards to actual disputes. It's like the boy who cried wolf. Like when you send a button, if you dispute everything for whatever reason, they're not going to take your other. They're thinking you're just sending an influx of disputes. They're not going to take your actual real inaccuracies seriously. So be careful what you actually dispute. All that comes into play, and everything comes out if your client ever needs to actually sue the credit bureau. Any false statement made by anybody can always be used against them in the court of law. That's not just a criminal law thing. It's not just the Miranda right. Any false statement can be used to prove that somebody's lying in a certain situation. And if I am dealing with an identity theft case with Experian years down the line, and they pull up this letter that I sent through my agent, I sent to Experian saying that I need the bankruptcy off the report. It's not mine, or whatever like weird reason I use to try to get it off. Experian is going to come back and say, hey, they lied this one time to us. What's to say they're not lying now? So like this type of stuff, it always comes back to bite you. So just be careful what you dispute on behalf of your clients.
Yeah, great advice and this is why we use action plans, you guys. That's what, our group that we have on Facebook is called the Credit Action Plan because it all ties into this. You create action plans for the clients. The clients have to do the work. There's nobody that can repair their credit except for them. They usually just don't know how. Okay, that's usually the issue. They just don't know how to repair their credit. They don't know what the first steps are. They're overwhelmed. They just see this report with a bunch of numbers on it and their credit score is super low and they have no idea where to begin. They want guidance and they need guidance. It doesn't mean you need to go send in a whole boatload of frivolous disputes to try to remove everything off their credit report. Give them a real action plan. Dispute the actual inaccuracies that are on the credit reports, the obsolete items, things like that, because they're there. There's plenty. You all have FCRA violations just sitting in your files right now. I can promise you that. And you can get these things removed different ways. You can get their score up a lot of different ways. But if you just send in, 20 frivolous disputes in to trying to randomly get items off, it's just going to hurt things and you won't have cases moving forward because you've kind of screwed that up for yourself. So it's just a better, cleaner way of doing credit repair. And trust me, the clients like it better. I can't tell you how many times I've had clients tell me, oh my God, why didn't anybody tell me this before? Why didn't anybody tell me I just needed to get, a couple secured credit cards? Why didn't anybody tell me to just pay this item off or settle it and it would be done and go away? Like they don't get that kind of information from credit repair companies. So this is where you can really set yourself apart and be a real financial, guide to them with their credit. And that's what we love teaching here. So we have another question in here. If you settle on a charge off and the regular creditor still shows that it's a charge off, is this a violation? So I think the question which is really asking is, if the report still says charge off after something's been settled, is that okay? Because I believe that's kind of a
Paid,
myth floating
yeah,
around out there
I
too.
think it's supposed to update to say paid charge off. But if it was
Hey,
charge off at one point, I don't think it's inaccurate for them to use the terminology charge off, but they should specify that it was a paid charge off.
yeah. Yeah, I've seen that out there, people saying that you can't do that, but you absolutely. Can a bank put a checking account? This is Janelle. Can a bank put a checking account debt on your credit report?
It's my understanding that all debts can appear on your credit report. If yeah, I think so. I don't think there's anything there. The bank is a furnisher of information. They have that agreement with the credit bureaus. I don't think there's anything preventing them from reporting, especially if it's in collections. It's probably in collections if it's appearing on your report, but I think it's fair. It's a consumer debt.
So Neil just had a comment, not so much a question. Neil said, you can also use the early exclusion rule if you know about it. That also goes for any type of account. So that was more of a comment.
Yeah.
So I'm not sure what that is.
Yeah.
Talking about the Experian early delete for 30 days before the item is scheduled to be removed. That's what Experian has. I don't know anything else if I've ever heard of that exclusion. Neil wants to elaborate on that. That'd be great.
Yeah, I don't have any experience with early exclusion or anything like that.
Okay, and then Timothy Williams, his question is, if BKs are not reported by the BK courts, which law makes it legal to utilize third-party data?
The Fair Credit Reporting Act. It's not illegal for a credit bureau to obtain that information from a data vendor like LexisNexis. It's not just that someone has to report the information or a furnisher has to report the information to show up on your credit report. If it's public information, if it's public record, it can appear on a credit report.
Yeah. So that is one of the biggest things we see floating out there. That is just a myth, you guys. Like, there's nothing saying that the bankruptcies can't report. And I see this over and over and over and over. It's fine. They can report it.
I think it's the single biggest myth in credit repair is that they don't have the right to report the bankruptcy
Right.
because the bankruptcy courts don't report. The bankruptcy courts aren't a furnisher. They're just a public institution.
Yeah. So you guys can, yeah. So that's right out of the attorney's mouth, you guys. That does consumer law. You can absolutely, it's perfectly legal to report a bankruptcy on a credit report. Um,
And
Janelle
if
has another question. Can a
yeah,
creditor report 96 late payments on a closed account? Are they prior to it being closed, Janelle, or after it being closed?
yeah, I think we need that clarification because if it's after it's closed and it's an actually closed account, then I see some problems there. But if it was 96 up until the point it was closed, I guess we know why it was closed. So
Okay, Timothy has another one. So we're running out of time. We have 5 minutes. So I'm going to try to blow through these, and I see a lot of messages coming in. If there's no creditor or actual data furnisher listed on your credit report for the BK, can you dispute it that way?
they don't have to say where they are sourcing that data. There's no it's not coming from a furnisher. It's coming from a data vendor. The way they scrape your addresses, the way they scrape your birthdays, the way they get that information, no one's reporting that information to the credit bureau. That's stuff that they get through data records, that data vendors or public records. So there's no yeah no, so you can't dispute. There's no valid legal basis to dispute the bankruptcy because there's some creditor behind it. So or the fact that someone's reporting it or bankruptcy courts can't report it.
Can you hear me, sir?
Yeah,
All right. I've been doing this about 15 years, and I trust me, I totally understand what you're saying. But according to the Fair Credit Reporting Act, you have to be a creditor or a data furnisher to be posted on someone's credit report because you have a right to dispute directly with that creditor or that data furnisher. So in this case, the bankruptcy courts, if you dispute with them, they're going to say, "Well, we never reported." So where you at with that? Because there's no data furnisher reporting on your credit report, which violates the Fair Credit Reporting Act.
yeah, I disagree. I think it's different for public records on a credit report. These aren't accounts. And then if you dispute it, the public records, the actual pacer will show what it's supposed to show. So it doesn't mean that a creditor or a data furnisher needs to verify a bankruptcy, maybe accounts, but not a bankruptcy, because that can be in the public record.
Right, I agree with you. That's the accepted process. But like I said, according to the Fair Credit Reporting Act,
Hey,
yeah.
file a lawsuit on it, and I would love to see what the courts come down with because if they don't laugh you out of it, if they don't laugh me out, I wish I could do that. I mean, but it's just not a thing.
I just want to get your point of view from it. I mean,
Yeah.
that's the standard. What you're saying is the standard. They do what they're gonna do regardless.
I think it's
And
a clever argument. I think it's a clever argument, but I just don't see it sticking, or I don't think a judge would take that seriously. I
Okay, so
don't.
Diana wanted to know if the replay will be available. Yes, Kim sends the replay out the next day, so everybody will get the replay. Just making sure if we have any other questions because we're down to 2 minutes here.
Yes, this is Janelle, and they reported that the account was open after it was closed, and then they reported 96 late payments on my personal credit report.
So opened after it was closed, and how is it? Was just one bureau, or is it the other two too?
I believe it's 2.
And it's two of them. Did you dispute it?
Yes, I did with FCFPB, and they tell me furnished it is verified, and I know it's got to be illegal.
Did you dispute it with the credit bureaus? I think that's where
Yeah, I did with all of them. With all of them,
okay, and they verified it as accurate, and those lates. Yeah, I'd have to see the account, but I think there could be something.
96 late payments.
Send it to him so he can look at it, Janelle.
Yeah.
Okay.
Yeah,
So
send it over to him.
QR
I have
code.
one more question, and I'm gonna just definitely send it over. We don't want to try to get into actual issues on this call because we have like 1 minute. So, isn't it a law not to show anything unless you give them permission? We're gonna hit on that one.
That's not true.
So no, you guys,
No.
it is not a law. You do not have to give them permission to report things on your credit report.
Are you doing maybe?
Is it necessary to
Okay.
freeze the secondary bureaus right quick?
No, I don't. You don't have to dispute. You don't have to freeze your other bureaus before you dispute.
No. It doesn't stop, freezing bureaus does not stop anything from being verified. Again, these are myths. All right. So, all right, we're gonna end because it is 5 o'clock. So we always end on time. I do respect everybody's time on these calls. So this was a great call, you guys. We will have Haseeb back because I know there's 50 million other questions for him, but also get in contact with him. There's a QR code if you want to do a demo with Credit Butterfly, and we'll show you how we track the FCRA cases in there and get them over to the attorney. And it's so fast and it's so easy. Go ahead and schedule a demo. Get a hold of Haseeb. I'll put his back on real quick if in case you didn't get a screenshot or a photo. There's his email and his phone number. Hit him up.
Yeah,
He
let
is
me
looking
let me know
forward
you
to
were on this
talking to
call.
you.
Yeah, let me know you were on this call, and send me your bankruptcy reports. Tell me you were on this call, and then I'll be happy to look at them.
All right, and we're going to go 1 minute over because there's one more thing. And I actually like this question, so I'm going to go ahead and let this question go over time. What is permissible purpose? Please go
Well,
ahead and explain that if you
Well,
can.
when somebody makes an inquiry on your credit report, it has to be you who did it, and it has to be for a reason. So, like if you go apply for credit or like a house or any type of loan, if some random is pulling your credit, you could sue them under the FCRA's permissible purpose, because they didn't have a permissible purpose to pull your credit report. So that inquiry is the basis of the litigation.
All right, guys, thanks so much. I appreciate everybody that came on the call today. Make sure you guys get a hold of Haseeb for all of your bankruptcy issues, and we'll see you next week.
Well, thanks for having me, guys.
Thanks. Good night.